This is from days 28 and 29 of the Karen Reed trial. Dr. Stonebridge was on the stand. She is a forensic pathologist, a neuropathologist, among other things. She works at the ME's office. She's highly qualified. She examined Officer O'Keefe's brain, and she was asked to do that by the medical examiner. The information she had from intake was the autopsy report, the ER report. She had the police report and EMS report. She testified basically that Officer O'Keefe suffered acute injuries to the brain. He suffered hemorrhaging that was due to trauma, not an aneurysm. She said there was hemorrhaging in the frontal poles, the left temporal lobes, left temporal pole, and left lateral fissure, also the posterior surface of the right. We're talking about the brain. She said there was herniation in the brain, and this caused bleeding in the brain stem. There were multiple contusions on the brain itself, and she found diffuse hemorrhaging in the brain stem. Diffuse means over a large area. The bottom line here is this man suffered a massive brain injury. She said that her opinion was that the injuries she saw were due to trauma. Lally asked her about the mechanism and the force, and she said she can't say what type or how much force. She agreed with Lally that the injuries could be consistent with a fall or being struck by a vehicle. But recall that the Commonwealth's own witness on accident reconstruction, Trooper Paul, said John was struck in the arm, that he spun around, but somehow he landed in the yard and maybe he hit his head on the curb. Even the Commonwealth's own witness does not say that the SUV struck John in the head or the face. If John had fallen backward and struck his head on pavement or a curb, that would be consistent with what this doctor is saying. However, it would be inconsistent with what was found at the scene and where John was found at the scene. But it is consistent with falling backwards onto a cement floor. The doctor's saying it's consistent with a fall. So I think this doctor's testimony supports the defense more than it supports the prosecution. But it's going to matter what the jury thinks. And of course, Lally didn't ask if the injuries were consistent with being struck in the head by, say, a heavy, blunt object. But of course, he's not going to ask that. The defense chose not to cross-examine the witness. The next witness was Dr. Scorty Bello. Lally asked her what was the first thing she noticed about Officer O'Keefe's body, and she said there was evidence of attempts at resuscitation. Lally asked her about the different determinations as to manner of death. They are natural, accidental, homicide. She said in order to rule homicide, she has to see some evidence of intention to cause fear, injury, or death. That's pretty broad. The fourth is the S word that I can't say on YouTube, and the fifth is undetermined. And she said that it's undetermined if the evidence pointing to one manner of death is no more compelling than evidence pointing to another manner of death. She said the cause of death is based on medical findings. The manner of death is based on the investigative information provided. She said there was no evidence or very little evidence that the death was intentional. She talked about all the different things she did during her examination. And one of the things that she mentioned was looking at the fingernails and they got those nail clippings. And I don't recall any DNA results from those fingernails. Do you? If there was any kind of a struggle with another person, there very well could be somebody else's DNA under the fingernails. So what happened with that? Did they just not bother? If you recall that being testified about as to whether or not they did testing and what they found, let me know exactly where that is in the trial so that I can go and look at it, because I don't remember this. This doctor said that the cause of death was blunt impact to the head and hypothermia. She said the manner could not be determined, but she agreed it was not the S word and it was not natural. It was accident or homicide, and she can't say which. What it doesn't tell you is who is involved in the accident, if that was the case, or who committed the homicide. She gave definitions of contusion, abrasion, fracture, and laceration. A contusion, when she refers to that, is a bruise. An abrasion is a scratch or a scrape. A fracture is a break in a bone. A laceration is a tear in the skin, and she distinguished this from a cut. So a laceration is a tear, but a cut is more like a slice, and they are different things. She said he suffered blunt force to the face and head and upper extremities. He had hemorrhaging under his eyelids. He had swelling of the eyes. He had a tear in the skin of his right eye and his nose, and he had a laceration on the back of his head. She described the injuries to his arms as linear patterned scrapes. Usually when you have an injury that is patterned, investigators go looking for something at the scene that would cause that particular pattern. And very often they can figure out what that was. In this case, that wasn't done, not by anybody on the Commonwealth side anyway. She said he had bruising on the back of the right hand. She said he had a small abrasion on his right knee. She said there were 2 contusions to the back of his hand and a scratch to the back of his other hand. This is different from contusions to the knuckles. Just look at your hand and go above your knuckles, between your knuckles and your wrist, and that's where those contusions were. She said that one of the 2 contusions on the back of his one hand could have been caused by attempts at putting in an IV. She didn't speculate on the cause of the other contusion or the scratch on the back of the other hand. She said his skull was fractured back and front. She described seeing the obvious brain hemorrhaging. So when she saw that, she sent the brain to Dr. Stonebridge. The fracture on the back of his skull was slightly right of midline. She said there were multiple fractures in his skull. In the stomach, she noted small hemorrhages, and these are associated with hypothermia. She said there was diffuse hemorrhaging in the pancreas, which is also a finding associated with hypothermia. The other support here for finding of hypothermia was his body temperature and the fact that he was found in the snow. She said she did see photos of the scene. Blood alcohol level was tested from 2 different locations, meaning blood and a fluid. And to summarize that, she basically said that his blood alcohol level at the time was on its way down. And I find this interesting. When a person consumes alcohol, the blood alcohol rises over time. The body starts to break it down, and the level of alcohol starts to decrease after a period of time. If the person continues to consume alcohol during this time, well, they have a new level of alcohol coming into their system that has to be broken down. Well, if his blood alcohol level was on the way down, that means he didn't just have a drink. If he just had a drink 10 minutes before, then the blood alcohol level would still be on the way up. So he was alive for a period of time after he left the waterfall. How long and in what condition is not something I can speak to. I'm not qualified for that. Lally asked her about hypothermia, And he asked obvious questions, but he wanted to get these things on the record, I suppose. So she agreed that the fewer layers of clothing, the faster a person becomes hypothermic. Wet clothing will speed up heat loss, and alcohol inhibits the body's warming mechanisms. I'm going to play you a clip where she shows a chart of his facial injuries, and I'm going to let her explain it because she can do it faster and better than I can.
Had ecchymosis or blood under them. On the right side, there was a very small laceration or a small tear associated with that. Both eyes had some swelling to them. And then on the nose, there were two abrasions, two scrapes. One was small at 0.5 centimeters. The other one was 1 centimeter, and it was linear. And I noted them right there. This is the area where I noted the laceration to the scalp. I noted something called tissue bridging, which is a morphologic feature of a laceration. Is what makes it different from an incised wound or from a cut, because again, the skin is crushed, and now it's more irregular. The edges are more irregular. And then above that laceration, I noted that there was a scrape as well associated with it. So that was one injury.
More, if you could expound upon, when you use the term ecchymosis, what exactly does that mean in specific reference to the area of the eyes?
Ecchymoses are a word that we use to describe bruising. Orbital ecchymoses or periorbital ecchymoses or supraorbital ecchymoses just refer to the location of the bleeding in relation to the eye. When we see ecchymoses or bleeding around the eyes, one of the differential diagnoses, one of the etiologies is blunt trauma to the head, and specifically fractures to what is known as the base of the skull. And this, what you're seeing here, is the base of the skull.
Now, doctor, if you could, using that diagram up on the screen, explain to the jury, when we asked first, as far as were you able to formulate an opinion to a reasonable degree of medical certainty as to how the injuries within the skull and the brain
So the injuries inside the skull, this is the base of the skull. This is, think of it as the tray where the brain would be sitting on top. The brain has been removed, and now we're looking at the bones. Right here is where I noted the skull, one of the skull fractures to be originating or starting with fractures. These are linear fractures that are extending or radiating from this one point of impact. This is known as the posterior fossa of the base. These two chambers are known as the middle cranial fossa, and this area is known as the anterior cranial fossa. As you look at this, the eyes would be sitting back here. So the eyes are actually very intimately associated with the anterior cranial fossa, which is very thin, and the bones are quite thin and friable. So an impact to the back of the head was in this case, because we do have a laceration and we do have an abrasion. So we know that the head impacted something blunt with enough force to break the skull and enough force for those fractures to propagate or radiate into the middle cranial fossa and also the anterior cranial fossa, which is the front chambers of the base. When the anterior cranial fossa are fractured, as I mentioned, they are very thin bones. Blood can seep from this area into the soft tissues and manifest as hemorrhage or bleeding or a contusion or an ecchymosis around the eye when you look at the person face, when you look at their face. So it is a well-known fact that fractures to the base of the skull can present with orbital ecchymosis, and that particular manifestation has a name. It's called raccoon eye because it resembles, I guess, what raccoon eyes look like.
Lally wanted to know what kind of force or what amount of force would cause these injuries. And as expected, she said the amount of force would be considerable, but she can't give a number. The witness just before her also said, can't tell you what type of force or how much. The doctor said she believed he suffered the injuries first and the hypothermia later. She said that the injuries to his head were not immediately lethal. She said he could have been knocked out and he could have been incapacitated, but in any case, because of the injuries, he wouldn't have been able to help himself. And I go back once again to the blood patterns that were on top of the snow and the blood stain pattern on his clothing. He didn't fall and then stay there. Otherwise, the blood could not have dripped down onto his shirt and onto his jeans in the manner that it did. You wouldn't see the blood where it is if he'd just been laying there and unable to get up. She can't give any specifics about the time of when the injuries occurred or the time between the injuries and when hypothermia set in. And Lally asked her about the scene because she'd seen scene photos. The way she put it was she saw some of them. And Lally is really trying to get her to say something here. I think he was trying to get her to point to something that could be a cause of the injuries. But she didn't say that. She didn't even go there. And really, if she saw something at the scene that made her think, oh, gee, hey, look at this item at the scene. It matches this injury or that injury. She might have said something about that, but she did not. So Lally's trying to get her to say something, and she doesn't. Not only does she not say what he wants, she comes out with, there didn't appear to be a lot of disruption in the area. And Lally asked her, well, what about an altercation? And she said there were no major signs of significant altercation. He did have a contusion on the back of the hand, but there was no bruising on the knuckles. So this was not some consensual fight. Officer John O'Keefe was a big guy. If you want to incapacitate a big guy, you might ambush him. I don't think this was an argument that got out of hand. I don't think this was a shoving match or a boxing match that got out of hand. There were no signs that John O'Keefe was hitting anybody. And think back to at the waterfall when Jen McCabe, who does not like Karen Reed, was saying to her, you're coming with me. Why? And think back to how it was so important for everybody to believe that Brian Higgins and Brian Albert did not arrive at 34 Fairview together and that they did not arrive before everybody else. There is something more to this whole thing. I don't think that this was an accident. I do not think that this was a fight that got out of hand because John O'Keefe's knuckles are not bruised. I believe this man was ambushed and it was planned, and there are some people who don't want anyone to look under the surface and they don't want anyone to ask why. And as you know, throughout the trial, the defense has brought up a few times the fact that O'Keefe didn't have injuries that you would expect to see as a result of a motor vehicle strike. No injuries to the torso, no injuries to the knee. Mind you, there's a small contusion, but you would expect much more than that. No injuries to the pelvis, etc., etc. And during the autopsy, the ME found rib fractures. And Lally, of course, jumps on that. And the ME said they were as a result of the CPR attempts and that it's common for those particular ribs to fracture in that particular location as a result of resuscitation attempts. And Lally asked a weird question. Weird in the sense that it was coming from him and not the defense. He asked the doctor if it requires less force to break ribs than it does to break the skull. And of course, the doctor says, yes, the skull is very thick. It requires more force, and the ribs require less force to break. And I thought it was weird he asked this because doesn't he want to prove that O'Keefe was hit by a vehicle? And the very point that the defense is making is, hey, he has no other injuries that would be consistent with a motor vehicle strike. And the defense has pointed out, hey, why aren't his ribs broken? Why doesn't he have injuries to his pelvis, et cetera, et cetera? And Lally just sort of supported their argument there through his questioning. Lally asked about vasoconstriction. And I suspect, I don't know, but I suspect where he was going with that was blood loss. Because if there's vasoconstriction, you're going to lose less blood. And that is part of the purpose, according to my training, which is very specific, and I'm not a doctor. We're taught that stress in a life-threatening situation can actually save your life because one of the things that happens is vasoconstriction. I think what Lally wanted to do was come up with some explanation for why there wasn't a lot of blood in the snow. Where did the blood go? But instead of giving Lally what he wanted, or what I think he wanted, the doctor said that in the cold you can see vasoconstriction and vasodilation. And she said she didn't see that, but that's because Officer O'Keefe had already been in the ER and they had tried to warm him. And then after he passed away, he was held for a period of time. So she didn't see him immediately. So she wouldn't see that. Lally asked about her receipt of information from the state police. She said it's the ME's responsibility to list the cause and manner of death. The scene is controlled by the DA. The ME always gets a police report, and that helps to explain what investigators saw. The ME's office will contact investigators if more information is needed. And Lally asked her about that. She said she did ask for more information. She said she didn't have enough information to determine the manner of death. Sometimes in the days and weeks following a death, investigators find more information. So she thought maybe they found more information, so she reached out. She has 90 days to do a report, but by the end of that time, she still didn't have enough information to determine the manner of death. The person she spoke to about this was Trooper Proctor. She said she spoke with him twice. Lally asked her, did you feel pressured to make a determination in a particular way? And she said no. And then he asked, if you had, what would you have done? And she said, my response was, I'm responsible, basically, to make these determinations. I thought it was interesting that she said my response was, not my response would be. Lally showed her photographs of John's body, and she points out evidence of medical intervention, the abrasions on his arm, the discoloration of his right eye. She pointed out the injuries on the arm and again said they're patterned. And when they see that, they always make note of that. She said those particular injuries did not contribute to the cause of death. And I will note that even though they didn't contribute to the cause of death, they are still evidence. It just falls outside of her role. She said she does not know what caused those injuries. She said the contusion on his right hand could be attempts at IV access, but she can't be sure. As she was viewing photographs that the police took at the hospital, she said she couldn't see from the photograph the injuries to his nose, and she said it wasn't a very good picture of it, which is a little bit surprising because CSIs get trained on how to take a good photograph. He again went over the laceration to the back of John's head. She said it's a classic blunt impact injury, and you can see a scrape next to it. The bleeding under the scalp was located under the laceration, and for some reason, Lally was trying to get her to say it was the right side. Well, The laceration was on the back of his head, just to the right of the midline. So I don't know what's up with him, why he wants it to be on the right side. And everything she said so far is as expected. Then Lally asks her basically what the blunt object was. And she says it could be anything. Well, she testified to this already. The other medical expert also testified to this. They don't know what the object was. It was a blunt object. And he started leading again. He asks if it could be consistent with a fall on pavement, and she said it could be consistent. And I'm going to play you a clip because he is really trying to push her to say what he wants, and she's not saying it. And when he asks her the questions, I want you to watch her body language because I think it adds to the words that she's saying. Here it is.
The injuries that you observed to the back of Mr. O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object, say in a pedestrian collision, and then striking your head on the ground?
It's possible.
The arm injuries that you observed, would those be consistent with scratches from either glass or a piece of plastic or a piece of metal?
It's possible.
Lally wanted to get her to say that these injuries could have been caused by a car accident or being struck by a motor vehicle. And she said they're not the classic injuries you would see.
Would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
Lally keeps scoring goals for the other team. And Lally still wants her to say what he wants her to say. So he asks her, are all injuries in a pedestrian motor vehicle collision the same? Well, of course, the answer is no. You know what he's going for here, right? He's going for within the realm of possibility. Because you know what? That's the best he can do. Within the realm of possibility. Does that sound the same as proof beyond a reasonable doubt? He wants could be consistent. Does that sound like proof beyond a reasonable doubt? He asked her, well, does the size and shape of a vehicle make a difference in respect to what injuries a pedestrian would suffer? And she said, yes, that is one factor. And she named a whole bunch of other factors. He asked if she'd seen a picture of Reed's SUV. And she said, yes, she had. And she looked at it. She said that in the majority of these pedestrian motor vehicle incidents, you see injuries to the legs. And in O'Keefe's case, there were no injuries to the legs. So Lally's getting her to talk about the size of Reed's SUV. And she said she did note that the vehicle was a larger vehicle and that it had a higher bumper. So again, with possibilities and suggestions, she did not say, and that would account for the difference and therefore his injuries are consistent. That's not what she said. She said she noticed the vehicle bumper was higher up. And a suggestion of guilt and suggestion piled on insinuation, piled on stereotype, placed within the realm of possibility that might be consistent, and another suggestion and an implication, they still do not add up to proof beyond a reasonable doubt. Just because you pile it all on doesn't mean that it's proof. And Lally repeated things that he already asked her. He went on about the thickness of the skull, and he asks how much force it would take to cause a fracture. And again, she says, a significant amount of force, but I am unable to quantify. He asked her again about, in her medical opinion, to a medical certainty, what was the cause of death. And she said, cause of death was blunt impact to the head and hypothermia. And I noticed that since he's having her repeat her findings, he doesn't ask her to repeat the manner of death, which is undetermined. Ms. Little did the cross-examination, and the witness agreed that blunt impact is a large category. The witness also agreed that within that category, there is a large range of objects that could cause blunt impact. And Little gave some examples, to which the witness answered. He said, bat, the answer is yes. Dumbbell, yes. The ground, yes. And then Little asked, and German Shepherd claws? And that seemed to throw the witness for a second, but she thought about it and said yes. Little went through with the witness the fact that John O'Keefe didn't have any significant injuries from the neck down, no broken bones aside from what was caused to the ribs right at the sternum due to CPR. Little went through them. No injuries to the shoulder, chest, torso, back, hips, pelvis, thighs, knees, shins, ankles, feet. No significant injury to any of that, not a single broken bone. Little asked her, even at the height of the bumper of Reed's SUV, having no injuries would be inconsistent with being struck by a vehicle at 24 miles per hour. And interestingly, the witness said, likely and unlikely. It depends on the positioning. And Little was trying to provide the scenario that is basically what the Commonwealth has provided to the jury and get the witness to say, no, that's inconsistent. But she kept asking these compound questions like the vehicle spins the person and then throws them so many feet and all of this. And so Lally's objecting. And while they're going through all this, the witness she's got this look on her face like, what the heck is going on here? Little asks, is the injury to his arm inconsistent with a strike from this vehicle traveling at 24 miles per hour? And it's the witness who finally puts an end to all of this and says, I don't know. I'm not a reconstructionist. I'm not a biomechanical engineer. Oh, but you know who is? One of the defense witnesses. Little has the doctor look at photos and point out the injuries on the face, and she does that as expected. Little shows an autopsy photo of the victim after his face had been cleaned up. So you can clearly see these facial injuries, and she has the witness describe them. Little got the witness to clarify that all of these injuries on the face are also as a result of blunt force. Little asked if the injuries were consistent with being punched. The witness said that is a possibility. So, yes, it's consistent, but it's only one possibility. There are other possibilities. Then Little brought up a laceration to John O'Keefe's tongue. And this is something I had not heard yet. This has not been brought up in trial yet unless I completely missed it. The witness agreed that the tongue laceration could be a blunt force trauma from a punch. She said that's a possibility. Little moved on to the back of the head. So there's the laceration, but right next to the laceration, there's a scratch or scrape. And Little asked if it's possible that that came from being dragged. And the witness said, yes, that's possible. And I notice there are subtle differences in how this witness answers when she says something's possible. There are times when she's very hesitant, and so far all of those times have been when Lally's trying to make her say something. And other times she's saying, yes, as if that's plausible, but she knows she can't say, oh, that's the thing. She can't narrow it down like that. She knows that. And so she's not going to do it. I like this witness. And in formulating a question, Little asks, so you'll agree that the injury to the back of the head, the laceration, was caused by some blow to the back of the head, which could be an object or the ground, right? And Lally objected. And maybe he objected because it sounds like she's leading rather than laying a foundation to go somewhere. Except it was Lally himself who was wanting to drive home the point that the injury came from an impact. What, did he not like the word blow to the back of the head? Did he not like the fact that could have been an object? Little is still able to ask if the injury to the back of John's head could have been caused by a fall backwards onto concrete. The witness says it's possible. Could it have been caused by a blunt object such as a bat or a barbell? And the witness says it's possible. Then Little moved on to the injuries to John's arm, and the witness agreed that there were no fractures to the arm and there was no sign of bruising. The injuries to the arm were described as discrete linear abrasions. And Little asks, what does that mean? What does discrete mean here? And the witness agrees that each one of these marks is an individual injury. And Little said, and you described them as being in a cluster or in groups. And the witness agreed. And Little asked about road rash and how road rash is usually not like this. And the witness agreed. No, usually it's not. Little tried to take it a step further to elicit the witness to say that this is absolutely not road rash, but the witness would not go that far. Little said to her, you've seen lots of instances of road rash through your career. The witness says yes. And Little says, they don't look like that, do they? And the witness says, correct. The witness agreed that blunt force injuries can be caused by numerous objects, such as an animal claw. And the witness said correct. The defense asked about the injuries on the arm and asked, could these discrete linear injuries be caused by hitting a smooth taillight at 24 miles per hour? Well, the witness cannot answer this question. The witness agreed she doesn't know what caused the scratches. The defense moves to a photo of John's right hand. She wants to introduce it, but Lally wants to approach. What for, Lally? Come on, man. The defense is able to use it. They show a picture, and the witness agrees that one of the bruises could be caused by an attempt to insert an IV. The witness also agrees that the reports from Canton Fire, EMS, the hospital all reflect that the IVs were put in his leg and then in a catheter. Little asked about the 3 separate wounds on the back of John's hand, and initially she said 4, and the witness corrected her and said, I see why you think it's 4, but I think it's 3. In any case, there are at least 3 separate wounds there, 3 separate bruises, and Little asks, are they consistent with defensive wounds? And the witness says yes. Then the defense moves into how the witness had stated there were no obvious sign of a fight because the victim's hands weren't broken and his knuckles weren't bruised and his fingernails were intact. Little gets the witness to agree that those are not the only signs of a fight, that there are many signs. Those wouldn't necessarily be the only defensive wounds had there been a fight. And the witness agrees with this. The defense takes the witness through some of the injuries. A laceration on the eye, multiple abrasions on the nose, laceration on the tongue, contusions on the backs of both hands. And they're all injuries consistent with a physical altercation. And Lally is objecting his face off, even when Little rephrases the question. Object, object. And I'm going to play the objection so you can hear his tone.
Objection.
The defense says to the witness, well, you saw photographs of the scene. The witness says yes. Those photographs were provided by Trooper Proctor. And the defense asks, do you have those photographs with you today? And the witness did not. So she asked her, do you recall what was in the photographs? And the witness does recall it. She said she saw the area of the fire hydrant and the area where Officer O'Keefe was discovered. And I want to point out two things here. One is there wouldn't be footprints in the snow because by the time it was light out, the snow would have covered any footsteps that came from the house or the yard to where O'Keefe was found. The other aspect of this here about footprints, we saw pictures from the scene right after paramedics moved John. And that's where you could see a little bit of blood in the snow where he was. And you could see footprints in the snow that were deep enough that you could see that the blood was on top of a significant amount of snow there. And again, I point out, it's not grass, it's snow. This question coming from the defense makes me wonder what photo Proctor was showing the ME and when that photo was taken. Because we know there were footprints in the snow from the people around John trying to assist him. So it'll be interesting to see where the defense goes with that little tidbit of information. The defense turned to the fractures in the skull and how those fractures could be from a single point of impact. And the witness agreed, yes. And recall, there were fractures not just to the back of the head, but also to the front. So the defense asks, could these other fractures have been caused by another impact? In other words, this could be a single point of impact, but could there be multiple points of impact? And the witness said, yes, there could have. And the defense asks, could he have suffered trauma to the face and fallen backward and suffered the impact to the back of his head? And the witness says that is possible, yes. And again, the tone is not very hesitant. It was a yes, that is possible. And I want to note something about the word possible and possibility and within the realm of possibility and all that. It has to apply differently to each side, to the Commonwealth and to the defense. And the reason is that the accused, no matter who he or she is presumed innocent, supposedly, unless there is proof beyond a reasonable doubt. So if the prosecution, in any case, provides proof, it's okay for the defense to say, wait a minute, there are some alternative explanations here that would explain it just as well, that would explain away the proof or what you're calling proof. Or there's a different interpretation of the evidence that favors the accused. And if there's a reasonable interpretation that falls on the side of the accused, that's what you've got to go with. You've got to go with the presumption of innocence, unless the evidence absolutely overwhelms that. So there's nothing wrong with the defense saying, is this possible? Is that possible? Because they're having to offer an alternative explanation. What's not okay and what should never work is for a prosecutor to try somebody based on possibilities. And so far, that's what we've got here. Possibilities, inferences, stereotype, insinuation. That's not proof beyond a reasonable doubt. And as for the proof that there is, well, it's all compromise. 6 ways to Sunday. And undeniable evidence of this defendant's innocence is present. It's been there from the beginning, but that is being ignored. And you know what? Whether you're a member of the public, whether you're on a jury, and certainly when you're a prosecutor, that's a problem. And that's a problem that goes beyond this case. The witness had previously testified that the bruise to the brain is likely due to a fall. The defense asked, is it possible that somebody could be punched in the face hard enough to cause a loss of consciousness and the person fall backward? And the witness said, it's possible. Everyone who has watched a boxing match knows that. The defense points to a spot of postmortem lividity and gets the witness to explain what that is. And the witness does explain it's lividity. it's not an injury. That was the end of the questions for the cross. Lally got up on redirect and brought up the minor abrasions to John's right knee and got the witness to say that they were on the lateral side of the knee, meaning the outside of the knee. And I think what Lally's trying to do is say, look, there is an injury to the knee. But, that's not caused by 7,000 pounds slamming into your knee. Sorry, Lally, it isn't. And if it's caused by a fall or scraping along the ground, well, it could be caused by a fall indoors too. And you know what else causes abrasions? Rug burn. But I haven't seen the picture, so I don't know. Lally said that the defense brought up possibilities as to the causes of the small injuries on the face. But that's only one possibility, right? And the witness agrees. He asks her, what are some other possibilities? And the witness said, a fall, a blunt object in the snow. Lally says, maybe glass. And she kind of hesitated. And the answer was that, well, it depends. Yes, I guess it could. Really, I think where she was going with that is it depends on what side of the glass you hit, right? Because if you hit the sharp side of the glass, it's going to leave a cut, not a blunt force injury. But if you hit the other side of the glass, well, then that's different. If he's going to make this insinuation, I want Lally to explain how he thinks that happened. Lally asks, could a piece of plastic cause these injuries to the face? And the witness says it's possible. But you know what? There was no taillight found in his wounds. There was no taillight found near his face. Lally asked, well, you testified that the injury to the back of the head could have been from falling backwards onto concrete. Could it also occur from falling backwards onto frozen ground? And the witness said it could be. And Lally asks, what other types of wounds, defensive wounds, might you expect to see that you did not see? So let's list all the possibilities that are not there. It's not even a probability, but okay. The witness said you could see multiple bruising on the forearm, cuts or lacerations on the forearm, and she's saying it's depending on how the person defended themselves and what position they were in. And I would add here, it depends on a lot of other things. And I think this witness is being put in a tough spot. Hey, witness, scientist, come up with every flippin' possibility in the universe so that we can pile these on, so that we can say, well, yes, even though the defense is saying that there's something that's a possibility, we want to point out that there's lots of possibilities. So we want to somehow, through that, discount them and say it doesn't matter that something's a possibility, except it does matter. But you know what? Defensive wounds are going to depend on a lot of things. For example, was the person ambushed? Did the perpetrator have a weapon? And in that case, you might not see any defensive wounds at all. Was there more than one attacker? Was one of the attackers an animal? Injuries to the forearm, lacerations. And it also depends on what, if any, weapons the perpetrator had, that the victim had. It depends on environment. There are so many scenarios that there's no way that this poor witness is going to be able to list them all. Lally moves to the right hand, and I think he's giving the witness a headache. Recall that this witness has repeatedly said that those contusions to the right hand are blunt force injuries. She said this over and over, and Lally asked, could the injuries to the right hand be caused by a blunt object? And I don't know how defense counsel keeps a straight face, or maybe they weren't. The witness says they are blunt force injuries. Then once again, Lally wants to know how the head injuries were caused. This witness has repeatedly said she does not know. She can't testify to that. So now she has to say it again. And then he wants her to re-explain the single impact injury to the back of the head, and pretty much leads her to say, yes, that single impact injury could cause all of the injuries to the skull. We already know that. Sometimes repetition is a tactic. It's a way to make somebody focus on a particular thing. It's a way to make people remember something. Sometimes repetition alone can make people believe something, even though if they sat and thought about it, they would know it wasn't true. So I know that is a tactic that gets used. But sometimes with Lally, I think he's like that little kid who asks the teacher for something and the teacher says no. And so he keeps asking because maybe if he keeps asking, maybe one time he'll get a different answer. Or maybe he'll find some little crevice into which he can stick his fingers and pry it open. He just keeps asking the same stuff. In the end, there were no more questions for Lally to ask. How many times can you repeat it? He'd run out. I do not think this was a win for the prosecution at all. And you know, we have not heard from any defense expert yet in respect to the medical stuff. I don't know how much of that we will hear, but this is still the prosecution's case. I think I'll end this one here. That's all I've got for you for now. Trust your gut. I'll see you in the comments.